with Lord's Amendment 42B. I will call the Minister to move the motion to disagree with Lord's Amendments 15B. Clear as anything. Minister.
Mr Speaker, clear as always. I'm very grateful to you. I beg to move that this House disagrees with Lord's Amendment 15B. Mr Speaker, it's an honour once again to open the debate on the retained EU law bill. We're now very close to passing this landmark legislation. We're fully taking back control of our laws, and we are ending the supremacy and special status afforded to retained EU law. Mr Speaker, as you so clearly outlined a few moments ago, there are three motions before the House this afternoon. Firstly, I'd like to speak briefly to the reporting requirements in Lord's Amendment 16C. I'd like to be the very first from the dispatch box, Mr Speaker, to congratulate my honourable friend, the member for Stone, for being awarded the Companion of Honour. And also, I'd like to thank him for his work on this amendment, alongside that of the noble lady Baroness Notes. It is, of course, important that we continue to update Parliament on our progress in reforming retained EU law, and that is exactly what we as a government are committed to doing with this clause. And I can reassure my honourable friend that the motion before us contains a drafting tweak only. The substance is exactly the same as that tabled by my honourable friend and supported by so many honourable and right honourable members on this side of the House. And I ask the House to agree to this final tweak to the drafting. Now, Mr Speaker, to turn to the parts of the bill where we have not managed to reach agreement with the other place. Firstly, I turn to Lord's Amendment 42B. I'm sure many of us in the Chamber will have followed their Lordships' debate closely. And the Government has not just followed the debate, but leading from the front, my right honourable friend, the Secretary of State, has worked to find solutions on the sunset, to resolve concerns with references to higher courts, and as I have already mentioned, we are committed to updating Parliament regularly on the process of reforms. Mr Speaker, it's clear that we have accommodated many of their Lordships' wishes, but I would respectfully suggest that now is not the time for their Lordships to insist on a novel and untested method of parliamentary scrutiny on the reform powers in this bill. It has been asserted that this amendment has precedent in the Civil Contingencies Act 2004. In fact, these powers have never been used. And let me be clear, it is not the government's intention for the powers in this bill to languish on the statute book. My right honourable friend, the Secretary of State, has already made the first announcement on regulatory reform and how we intend to reduce burdens for businesses and spur economic growth. And that is only the beginning of our ambition. I'll be delighted to give way to the honourable lady.
To hear the news. Caroline Lucas, please step in.
Thank you very much, Mr Speaker. I would just put it to the Minister that it is a bit odd to object to something simply because it's going to be a novel procedure. Everything is novel once, and if we're going to improve the effectiveness of Parliament, surely precisely what we need are some novel procedures.
Well, I'm very grateful to the honourable lady. May I join Mr Speaker in expressing exactly the same sentiments as him. I know that her campaigns will continue outside of this chamber, and I know that she will have lots to offer between now and then in any event, not least in the course of this debate. No, I disagree, and it's not just because they are novel, although they are novel. And I did follow the debate very closely, as I said, in their Lordship's House. And it is right to say that it is accepted that these are new measures. They are unnecessary, and this is why. Because this amendment would unreasonably and unnecessarily delay these important reforms. It would introduce what my right honourable and learned friend, the member for Kenilworth and Southam, termed extra friction during our previous consideration, and he mentioned that during our previous consideration of the Lord's amendments. He was right to say that, and right to say that this amendment would delay the meaningful reforms that can now be achieved as a result of Brexit. I do not believe that these delays are something the public would accept, and nor should we. I will give way to the honourable lady because it will give her the opportunity to apologise for getting the government's position on pension reform so wrong.
Well, I do hope then that the Minister will speak to his colleagues in the Department for Business who in the November the 22nd, I believe it was, committee stage, set out exactly that they were intending to abolish the Bauer and Hampshire judgments on the record. Perhaps he would ask his colleague to amend that rather than suggesting that I was misleading the House. I also notice, and it's welcome, that the Minister is now accepting that there is actually parliamentary precedent for amendable SIs. He talks about friction. Another way of describing this would be MPs holding the government to account if they come up with proposals that their constituents do not like. Is it the very nature of having called this friction? And I noticed that the ministers, when they were in front of the EU scrutiny bill, seemed to think it was an impertinence for MPs to have concerns and questions about what might be on the list of being deleted. Is that not another name for what we're calling it, parliamentary sovereignty?
No, not at all. The Honourable Lady is wrong, I'm afraid. And I'm going to come on to the parliamentary scrutiny that already is inbuilt within this bill and within the schedule to this bill. And I'll come back to the detail of that in a few moments. But the Honourable Lady was wrong over the weekend in her comments in relation to pension reform. This is important because people have been scared by what she said. The Hampshire case clarified that all scheme members should receive at least 50% of their expected benefits in the event of the employer's insolvency. The Secretary of State has been crystal clear on this, and we have announced our intention to retain the Hampshire judgment beyond the sunset clause. The Honourable Lady was wrong on that, and she is wrong on the provisions within the bill, and I will explain why in a few moments. But as has been pointed out countless times by honourable members on this side of the House, when we were members of the EU, as a democratically elected House, we could neither amend this legislation nor could we reject it. Demanding additional scrutiny now does not appear to be a consistent or comfortable position to hold. Where was their concern about lack of scrutiny during our EU membership? Of course I give way to them.
I'm very grateful to him for giving way. I'm one of the relatively few members of Parliament on this side of the House whose constituents voted by a majority to leave. And one of the issues around parliamentary scrutiny was something that was raised considerably during that referendum. I've had a number of them get in touch with me to say how disappointed they are that precisely the point he's making, that we're now not going to be getting the parliamentary scrutiny that we were promised was going to be one of the benefits of Brexit.
I'm sorry to say the Honourable Gentleman was wrong, and I'll explain why in a few moments, but I am grateful to him for his intervention, because it means that I can re-emphasise the point. This additional scrutiny that's being demanded is not a comfortable position for honourable members on the other side to hold, because they had no lack of concern about a lack of scrutiny during our EU membership. Let me turn to the Honourable Gentleman's precise point. This amendment is not only novel and untested, it's unnecessary, because there are already measures within the bill. We have already made provision for a sifting committee. And members, and Mr Speaker, you will recall the speech from my honourable friend, the member for Harrogate and Knaresborough, the chairman of the EU SI committee, who so clearly set out what he and his committee do. Important work. He described it as dry, Mr Speaker. It's important work that he and his committee do upstairs, scrutinising this legislation. That provision continues in the body of this bill. This will allow a specified committee in each House to recommend the affirmative procedure for the more substantive powers in the bill. In this way, either House will be able to ensure that there are active votes on the reforms that this government brings forward under the bill. This is significantly more scrutiny than the EU law had when it was first introduced. It is tried and tested. My honourable friend chairs that committee ably, and I'd like to thank him and all honourable members who serve on the committee for their work. Mr Speaker, turning now to the third and final motion, Lord's Amendment 15B. Of course I give way to him, gentlemen.
I'm grateful to him, but with the greatest of respect, under the previous arrangement, we had members of the European Parliament who were doing that scrutiny work. It's not really comparable to say, well, nothing's changed, it's somehow more. Because we've got rid of our representatives in the European Parliament, it's all the more important that these matters are considered. And so for him to say, well, look, there's a committee that deals with that, none of you will hear about it, but nonetheless its work is important, sounds like exactly the sort of thing my constituents thought they were getting away from.
Well, I'm sorry the honourable gentleman wasn't in the chamber for the exchange when my honourable friend, the member for Harrogate and Knaresborough, gently pointed out that actually members on that side of the House haven't taken up their places on the EU SI committee. He, quite rightly, as chairman of that committee, encouraged Labour members to take up their places on that committee, and I would add to that encouragement as well. Mr Speaker, the third and final motion is... Mr Speaker, I will give way, but I'm conscious that there are a number of people who want to speak, and I'll then make some progress.
With the greatest respect, I just wanted to say, with response to through the Minister to the member for Chesterfield, that in fact, although the European Parliament does its job, actually the laws are made by the Council of Ministers behind closed doors, by qualified majority vote and without even the transcript in Hansard. That is not a basis on which you can make any assumptions that we would ever agree to them. It was always done by consensus.
Mr. Speaker, you're absolutely right to encourage me to take that intervention. I'm very grateful to my honourable friend. And may I also pay tribute to him for all his work in this House. His announcement over the weekend would have come as a great sadness. A shock and a surprise. I know he's got a lot of work to do between now and the next election, and I look forward to these debates in the future. Mr. Speaker, thank you for encouraging me to take that intervention. The third and final motion. This amendment is both unnecessary and potentially detrimental to the environmental standards we have in this country. We've repeatedly made the commitment at every stage of this bill that we will not lower environmental protections and we will ensure the continued implementation of our international obligations. Indeed, Mr. Speaker, I'm reminded of the exchange and rare moment of agreement between my honourable friend, the member for North Dorset, and the right honourable gentleman, the member for East Antrim, during our last outing. They found common accord and they were both right. There is simply no reason or incentive for the government not to uphold our high environmental standards, of which we are rightly proud. It is simply not necessary for this commitment to be on the face of the bill, and especially not in a way that will make it more difficult to achieve any meaningful reforms that will benefit the UK. Mr. Speaker, I'm not going to try your patience by listing all of the government's achievements post-Brexit, but some of the steps we are taking go above and beyond the EU law. And as I said, well, they're encouraging me to do so. Mr. Speaker, they're encouraging me to do so. Well, who am I to say no? Our environmental standards. I'm keeping a very careful eye on timings and on your indication as well. So let me not abuse your patience, but let me just list some of the important measures that have been passed by this government. Our environmental standards are now world-leading, thanks to the Agriculture Act, thanks to the Fisheries Act, thanks to the Landmark and world-leading Environment Act, which will deliver the most ambitious environmental programme of anywhere. Furthermore, this amendment is not just unnecessary, it may even endanger our environmental standards. The amendment will make it harder to retain the effect of existing regulations as the amendment applies to restatements of retained EU law. And Mr. Speaker, it's very timely that the Secretary of State for the Environment has arrived in the Chamber exactly as I am championing all the steps that she and her predecessors have taken to protect and lead the world in our environmental standards. Mr. Speaker, this amendment adds friction, it is unnecessary, it is potentially self-defeating. On this side of the House, we want to ensure that we capitalise on the competitive advantages that the UK has now that we are no longer restrained by our membership of the EU. I invite the House to support the motions in the name of the Secretary of State. I beg to move.